I never thought buying an electric car would turn into a legal battle with my own neighborhood, but standing in my driveway with a cease and desist letter in my hand, I realized that's exactly where I was headed. My name is Thomas Richardson, and I had just moved into the Meadowbrook Hills community in Sacramento, California, 3 months earlier. The house was perfect for me after my divorce, a 3-bedroom ranch with a 2-car garage and a decent-sized backyard. I worked as a software engineer for a tech company downtown, and the commute was manageable. When I decided to trade in my gas-guzzling SUV for a Tesla Model 3, I thought I was making a smart, environmentally conscious decision. I had no idea it would lead to months of harassment, legal drama, and ultimately a courtroom showdown. The trouble started on a Tuesday morning in late March. I had scheduled an electrician to install a level 2 charging station in my garage. The installation was straightforward. They would mount the charger on the wall near where I parked and run the necessary wiring to my electrical panel. I had done my research, obtained the proper permits from the city, and made sure everything was up to code. The electrician, a friendly guy named Carlos, arrived at 8 in the morning and got to work. Around 10:30, I heard a sharp knock on my front door. I opened it to find a woman in her early 50s standing on my porch, her arms crossed tightly over her chest. She had blonde hair with visible dark roots, wore a velour tracksuit despite the warm weather, and had the kind of pinched expression that suggested she spent most of her time finding things to complain about. "Can I help you?" I asked, trying to sound friendly despite the obvious hostility radiating from her. "I'm Patricia Hendricks, president of the Meadowbrook Hills Homeowners Association," she announced, as if I should have recognized her on sight. "I need to speak with you about the unauthorized work being done on your property." I blinked, confused. "The charger installation. I have all the permits from the city. The electrician is licensed and insured." Patricia's eyes narrowed. "You did not submit an architectural modification request to the HOA board. Any changes to the exterior or interior of your property that affect the community's aesthetic or infrastructure require prior approval. This is clearly stated in your CC and Articus." "It's inside my garage," I said, feeling my patience already wearing thin. "How does that affect the community's aesthetic?" "That's for the board to determine, not you," she snapped. "You need to stop the work immediately and submit the proper paperwork. The board meets once a month and will review your request at our next meeting in 3 weeks. I felt a flash of irritation. "Look, I've already scheduled this, paid for the permit, and the electrician is here now. The charger goes inside my garage where nobody can even see it. I'm not stopping the installation." Patricia's face flushed red. "Then you'll be in violation of the HOA covenants and will have no choice but to take action. I'm warning you, Mr. Richardson." "Thanks for the warning," I said and closed the door. Carlos had been watching the exchange from inside the garage. "HOA problems?" he asked sympathetically. "Apparently." I shook my head. "Just finish the installation. I'll deal with whatever bureaucratic nonsense they throw at me." The installation was completed by early afternoon. The charger looked professional, mounted neatly on the garage wall with clean wiring. I plugged in my Tesla and it started charging immediately. I felt a small sense of satisfaction, thinking that would be the end of it. I was very wrong. 2 days later, I found an envelope in my mailbox from the Meadowbrook Hills HOA. Inside was a formal violation notice stating that I had made unauthorized modifications to my property and had 10 days to remove the electric vehicle charging station or face fines of $100 per day. There was also a copy of a section from the CC and Articus, the covenants, conditions, and restrictions that governed the community, highlighting the requirement for architectural approval. I sat at my kitchen table, reading through the document with growing frustration. The language was deliberately vague, talking about maintaining community standards and ensuring that all modifications were aesthetically consistent with the neighborhood. There was nothing specific about electric vehicle chargers, but the way it was written, the board could theoretically claim jurisdiction over nearly anything. I decided to do some research. I spent that evening digging through California state law, and that's when I discovered something interesting. In 2011, California had passed Assembly Bill 1092, later amended and strengthened, which specifically prohibited HOAs from unreasonably restricting the installation of electric vehicle charging stations. The law stated that any provision in a community's governing documents that either prohibited or unreasonably restricted the installation of such equipment was void and unenforceable. I read through the statute carefully. It made exceptions for reasonable restrictions related to things like safety and aesthetic concerns, but those restrictions had to be based on specific, documented concerns, not just blanket prohibitions. The HOA could potentially regulate where chargers were visible from the street or establish reasonable aesthetic standards, but they couldn't just ban them outright or make the approval process so onerous that it effectively prevented installation. Armed with this information, I drafted a response letter to the HOA. I kept it professional but firm, citing the relevant California Civil Code sections and explaining that their attempt to force me to remove a legally installed charging station from inside my garage was not only unreasonable, but also illegal under state law. I sent the letter via certified mail so I would have proof they received it. Patricia's response came faster than I expected. She called me directly the next evening, and I could hear the anger in her voice before she even finished her greeting. "Mr. Richardson, I received your letter and I have to say, I find your attitude extremely troubling. This community has rules for a reason, and no one is above them." "I'm not trying to be above the rules," I said calmly. "I'm just pointing out that state law supersedes HOA covenants in this case. You can't enforce a restriction that violates California law." "We'll see about that," she huffed. "The board has consulted with our attorney, and we're prepared to take this as far as necessary. You have until the end of the 10-day period to remove that charger, or the fines will begin." "Then I guess the fines will begin," I said, "because I'm not removing it." She hung up without another word. Over the next week, I consulted with my own attorney, a real estate lawyer named Jennifer Park, who had experience with HOA disputes. She reviewed all the documentation, my permits, the HOA's violation notice, my response letter, and the relevant state statutes. "You're absolutely right about the law," Jennifer told me during our meeting at her office. "California is very clear on this. The HOA can't prohibit or unreasonably restrict EV charger installation. The fact that yours is inside your garage and not visible from the street makes their position even weaker." "So what happens now?" I asked. "They'll probably fine you and you'll refuse to pay. Eventually, they might try to place a lien on your property or take you to small claims court. But here's the thing, when they do, you'll have a strong case for not only having the violation dismissed, but also for recovering your attorney's fees. The statute specifically allows for that." "How long could this take?" Jennifer leaned back in her chair. "Months, potentially." HOAs can be incredibly stubborn, especially when they feel their authority is being challenged. The board president sounds like she's taking this personally, which means she might dig in her heels even when it's clear she'll lose. "Great," I muttered. The good news is that you're clearly in the right. Just document everything, don't engage in any hostile communications, and let the legal process work itself out. I took her advice. When the 10-day period expired, I received another letter from the HOA informing me that I was now being fined $100 per day for the ongoing violation. The letter had a cold, bureaucratic tone, as if Patricia was relishing the exercise of her perceived authority. I didn't remove the charger, and I didn't pay the fines. Life continued normally for a few weeks. I went to work, charged my car every night, and tried not to think too much about the growing pile of violation notices accumulating in my mailbox. But Patricia wasn't content to just send letters. She started finding other things to complain about. First, she sent me a notice that my trash cans were visible from the street on a non-collection day. They were in my side yard, partially obscured by a fence, but apparently, someone could see them if they walked up to my property line and looked at just the right angle. Then I got a notice that my lawn was half an inch longer than the maximum allowed height according to HOA standards. Never mind that it had rained heavily that week, and I had simply waited an extra day to mow. Rules were rules, according to Patricia. The harassment was obvious and petty, but I documented everything. I took photos with timestamps, kept copies of all correspondence, and maintained a detailed log of every interaction. About 6 weeks after the initial violation notice, I received a letter informing me that the HOA was placing a lien on my property for unpaid fines, which had now accumulated to over $4,000. This was more serious. A lien could affect my ability to sell or refinance the property. I immediately forwarded the notice to Jennifer, and we scheduled another meeting. "This is actually good news in a way," she said when we met. "They've escalated to the point where we can take action. I'm going to file a lawsuit in Sacramento County Superior Court. We'll ask the court to declare the HOA's actions unlawful, remove the lien, and award you damages and attorney's fees." "How much is this going to cost me?" I asked, worried about the legal expenses. "I'll work on a contingency basis for the attorney's fees portion," Jennifer said. "If we win, and I'm confident the HOA will have to pay my fees along with your costs. You'll be out some money upfront for filing fees and costs, but you should recover it all." "Let's do it," I said. Jennifer filed the lawsuit in early May. The complaint laid out the entire situation clearly. My lawful installation of an EV charger in my garage, the HOA's unlawful attempt to force its removal, the accumulation of baseless fines, and the improper lien on my property. We cited California Civil Code Section 4745, which specifically addressed EV charging stations, along with several case precedents where courts had ruled against HOAs in similar situations. The HOA had 30 days to respond. During that time, I got a taste of what it's like to be truly ostracized by your neighbors. Patricia must have spread the word that I was suing the HOA, because people who had previously been friendly suddenly wouldn't make eye contact with me. One neighbor, an older man named George who lived 3 houses down, actually crossed the street when he saw me approaching during my evening walk. Not everyone turned against me, though. About a week after the lawsuit was filed, a woman named Helen Larson knocked on my door. She was in her early 40s, had kind eyes, and looked nervous. "I hope you don't mind me stopping by," she said. "I live over on Maple Court. I heard about what's happening with Patricia and the HOA." "News travels fast," I said wryly. "I just wanted to say that I think what they're doing is completely wrong. My husband and I have been thinking about getting an electric car, and when we heard about your situation, we realized they'd probably try the same thing with us." She hesitated, then continued. There are others who feel the same way. We're not all on Patricia's side. Her words were surprisingly comforting. I appreciate you telling me that. It's been pretty isolating. Would you be willing to come to a small gathering? Nothing formal, just a few neighbors who want to hear your side of the story. I agreed, and that Saturday I found myself in Helen's living room with about 8 other homeowners from the community. I explained the situation, showed them copies of the relevant state laws, and answered their questions. Several of them had their own horror stories about Patricia and the HOA board arbitrary fines, selective enforcement of rules, and a general atmosphere of intimidation. She fined us $500 because we planted roses instead of petunias in our front flower bed, one woman said, shaking her head in disgust. The CC and Articus don't specify what kind of flowers you can plant, but Patricia said roses weren't in keeping with the community aesthetic. She made us repaint our front door because the shade of blue was supposedly different from what was on file. Another man added, we had to pay for a color match analysis from a professional paint company to prove it was the exact same color. Cost us $300. I realized that my situation wasn't unique. Patricia had been running the HOA like her personal fiefdom, and people were fed up. But most of them were too afraid of retaliation to speak up. If you win your lawsuit, it might open the door for the rest of us, Helen said hopefully. Maybe we could even recall the board and elect new leadership. One step at a time, I said, though the idea was appealing. The HOA's response to my lawsuit was filed at the end of May. Their attorney, a lawyer named Douglas Werner, argued that the HOA had the right to regulate modifications to properties within the community, and that my failure to submit the proper paperwork before installing the charger constituted a violation, regardless of state law. The response also claimed that the charger could potentially cause electrical problems affecting other homes, a completely baseless assertion, and that I had been hostile and uncooperative in my dealings with the board. Jennifer was unimpressed. This is a weak response, she told me over the phone. They're throwing everything at the wall to see what sticks. The electrical safety argument is particularly absurd since you have all the proper permits and inspections from the city. What happens next? We go through discovery. That's where both sides exchange information and documents. Then we'll probably have a hearing where a judge will rule on the key issues. Given how clear-cut the law is, I expect we'll get a favorable ruling fairly quickly. The discovery process was tedious but revealing. Jennifer requested all documents related to the HOA's decision to fine me, including emails and minutes from board meetings. What we received was enlightening. The emails between Patricia and other board members showed that she had been personally affronted by my refusal to comply with her initial demand to stop the installation. In one email to another board member, she wrote, "We cannot let homeowners think they can just ignore the board's authority. If we let Richardson get away with this, everyone will start doing whatever they want." There was no discussion of legitimate safety concerns or aesthetic issues. It was purely about asserting control. Even more damning was an email exchange where Patricia asked the HOA's attorney about the California law protecting EV charger installation. Douglas Werner had actually advised her that the HOA's position was legally weak and that they should probably approve the charger. Patricia's response was telling. "Find me a way to fight this. I don't care what the state law says, we have our own rules." Jennifer was delighted when she saw these emails. "This shows a willful disregard for the law," she said. "It strengthens our case considerably, especially for attorneys' fees." The hearing was scheduled for mid-July. As the date approached, I felt increasingly nervous despite Jennifer's confidence. I had never been involved in a lawsuit before, and the idea of arguing my case in front of a judge was intimidating. Patricia, meanwhile, seemed to be doubling down on her position. She sent a letter to all homeowners in the community warning them about the dangerous precedent my lawsuit could set, and claiming I was trying to undermine the HOA's ability to maintain property values. The letter was full of inflammatory language and half-truths, painting me as some kind of radical who wanted to destroy the community. Helen forwarded me a copy, along with a note saying that several homeowners were planning to attend the hearing to show support. I was touched by the gesture. The morning of the hearing, I put on my best suit and met Jennifer at the Sacramento County Superior Court. The building was impressive, a large, modern structure with high ceilings and the kind of formal atmosphere that makes you instinctively speak in hushed tones. We were assigned to Department 12, and Judge Marion Foster would be hearing our case. Jennifer had told me that Judge Foster was known for being fair but no nonsense, with little patience for frivolous arguments. When we entered the courtroom, I saw Patricia sitting on the other side with Douglas Werner. She was dressed professionally in a navy pantsuit, and she gave me a cold stare as I took my seat. There were indeed several people from the neighborhood in the gallery, including Helen and her husband. Judge Foster entered promptly at 9 o'clock. She was a woman in her 60s with sharp eyes and an air of competence. After the bailiff called the court to order, she reviewed the file briefly and then looked up. "This case involves a dispute over an electric vehicle charging station," she said. "Counsel, let's keep this focused and efficient. Miss Park, you're representing the plaintiff," Jennifer stood. "Yes, Your Honor, Thomas Richardson is the plaintiff. We're seeking a declaration that the HOA's actions are unlawful under California Civil Code Section 4745, removal of the improper lien on my client's property, and an award of attorney's fees and costs. Mr. Werner, you're representing the Meadowbrook Hills HOA." Douglas Werner stood as well. "Yes, Your Honor. The HOA maintains that it has the authority to regulate property modifications within the community and that the plaintiff violated proper procedures." "All right, Miss Park, make your case." Jennifer was brilliant. She methodically laid out the timeline of events, showed the judge copies of my city permits, and explained how the charger was installed in compliance with all building codes and safety regulations. Then she turned to the law. "Your Honor, California Civil Code Section 4745 is explicit. It states that any provision in a community's governing documents that either prohibits or unreasonably restricts the installation of electric vehicle charging stations is void and unenforceable. My client installed a Level 2 charger inside his garage, where it's not visible from the street and poses no aesthetic concerns to the community." She pulled out copies of the emails we had obtained during discovery. "More importantly, the evidence shows that the HOA board knew their position was legally unsound. Their own attorney advised them that they would likely lose, but the board president, Miss Hendricks, insisted on pursuing this action anyway out of what can only be described as personal animosity toward my client." Judge Foster took the emails and read through them, her expression growing more disapproving with each page. "Mr. Werner," she said, "did your client ignore your legal advice?" Douglas Werner looked uncomfortable. "Your Honor, the board felt that the governing documents gave them the authority to enforce architectural standards." "That's not what I asked. Did you advise the board that their position was weak under state law?" There was a pause. "I did express some concerns about the strength of our position, yes, and they proceeded anyway." The board felt that the issue of procedural compliance, the failure to submit an architectural modification request, was sufficient grounds for the violation, independent of the EV charging issue. Jennifer jumped in. "Your Honor, that argument is a red herring. The HOA's governing documents can't require approval for something that state law says they can't prohibit or unreasonably restrict. Requiring a lengthy approval process for a protected activity is itself an unreasonable restriction." Judge Foster nodded. "I'm inclined to agree." "Mr. Werner, do you have any case law supporting your position?" "Your Honor, we believe that the HOA's rights to govern the community include reasonable procedural requirements." "That's not an answer to my question. Do you have case law?" "Not directly on point, Your Honor." "I didn't think so." Judge Foster set down the documents and looked directly at Patricia, who had been sitting rigidly in her seat. "Miss Hendricks, I'm going to be frank with you. Your HOA has wasted everyone's time and money pursuing a legally baseless case. The law in California regarding electric vehicle charging stations is clear, and it appears you chose to ignore both the law and your own attorney's advice." Patricia opened her mouth to speak, but Judge Foster held up a hand. "I'm not finished. HOAs serve an important function in maintaining communities, but they are not above the law. When state law conflicts with your CC and Artiques, state law wins. Every time." She turned back to Jennifer. "Miss Park, I'm granting your motion. The HOA's violation notices and fines are declared unlawful and are hereby voided. The lien on your client's property is to be removed immediately. Furthermore, I'm awarding attorney's fees and costs to the plaintiff." I felt a surge of relief and vindication. Judge Foster wasn't done, though. "I'm also ordering the HOA to pay a penalty of $5,000 to the plaintiff for the willful violation of Civil Code Section 4745. The statute allows for such penalties when an HOA acts in bad faith, and the evidence here clearly shows bad faith." Patricia's face went pale. Douglas Werner looked like he wanted to sink through the floor. "Your Honor," he began, but Judge Foster cut him off. "The HOA will also be responsible for all of the plaintiff's costs associated with this litigation, including filing fees and any other reasonable expenses. Miss Park, please submit a detailed accounting within 30 days. "Yes, Your Honor." "Is there anything else?" Jennifer glanced at me and I shook my head slightly. "No, Your Honor, thank you. This court is adjourned." As we left the courtroom, I felt like a weight had been lifted off my shoulders. Helen and several other neighbors congratulated me in the hallway. Patricia stormed past without a word, but I caught a glimpse of her face. She looked absolutely furious. "That went even better than I expected," Jennifer said, allowing herself a smile. "The penalty award was a nice touch. Judge Foster clearly didn't appreciate the HOA's behavior. What happens now? I'll prepare the fee application and submit it to the court. Based on the hours I've put in and the standard rates, we're looking at probably $20,000 to $25,000 in attorney's fees, plus your costs. The HOA will have to pay all of it," I whistled. "That's going to hurt their budget." "It should. Maybe it'll make them think twice before pulling something like this again." Over the next few weeks, the atmosphere in Meadowbrook Hills shifted noticeably. Word of the court's decision spread quickly, and Patricia's reputation took a serious hit. Several homeowners who had been previously afraid to challenge the board started questioning other rules and fines. Helen contacted me about a month after the hearing with exciting news. "We're organizing a recall petition," she said. "We need signatures from 20% of homeowners to force a special election for new board members. Do you want to help?" "Absolutely." The recall effort gained momentum quickly. It turned out that Patricia's heavy-handed leadership had alienated more people than I realized. Within 3 weeks, we had more than enough signatures to trigger the special election. Patricia tried to fight it, of course. She sent letters claiming the recall was organized by troublemakers who wanted to destroy property values. She argued that the petition had technical defects and should be invalidated, but the homeowners had had enough. The special election was held in early September. Patricia and 2 other board members who had supported her stance were voted out. Helen was elected as the new president, along with 4 other reasonable people who actually wanted to serve the community rather than lord over it. One of the new board's first actions was to formally apologize to me and update the HOA's policies to explicitly allow electric vehicle charging stations in compliance with state law. They also implemented new procedures to ensure that future board decisions would be made transparently and with proper legal guidance. Jennifer's fee application was approved by the court in late September. The total came to $23,000 in attorney's fees plus another $2,000 in costs. The HOA had to pay the entire amount, which put a significant dent in their reserve fund. Patricia was personally furious about this, but there was nothing she could do. I heard through the neighborhood grapevine that she tried to convince the new board to appeal the judgment, but they wisely refused. Douglas Werner had apparently advised them that an appeal would be frivolous and would only result in more costs. In October, about 6 months after this whole ordeal began, I came home from work one evening to find an envelope in my mailbox. Inside was a check from the Meadowbrook Hills HOA for $25,000, the attorney's fees, costs, and the $5,000 penalty. I stared at the check for a long moment, feeling a complex mix of emotions. I was relieved that it was finally over. I was satisfied that justice had been served. But I was also frustrated that it had taken so much time, stress, and effort to enforce a clear legal right. I deposited the check the next day and used some of the money to take Jennifer out for a nice dinner to thank her for her excellent work. The rest I put toward home improvements, ironically, none of which required HOA approval under the new, more reasonable policies. Life in Meadowbrook Hills gradually returned to normal, though it was a better normal than before. The new board was responsive and reasonable. They focused on actual community needs like maintaining common areas and organizing neighborhood events, rather than harassing homeowners over trivial violations. More homeowners started buying electric vehicles, and several installed chargers without any issues. The community even installed 2 charging stations in the guest parking area near the clubhouse, which was a popular amenity. Patricia remained in the community, but she kept a low profile. I would occasionally see her in passing, and we would exchange curt nods but nothing more. I heard she had tried to run for the board again at the next regular election, but lost badly. One Saturday afternoon in November, I was washing my Tesla in the driveway when George, the neighbor who had crossed the street to avoid me during the lawsuit, approached hesitantly. "Tom," he said, using the nickname I preferred. "Can I talk to you for a minute?" "Sure," I said, turning off the hose. He looked uncomfortable. "I wanted to apologize for how I acted during all that HOA nonsense. I should have supported you, but I was afraid Patricia would come after me next if I did." I appreciated the honesty. "It's okay, George, I understand. She created a pretty intimidating atmosphere." "She did. But you stood up to her and that took guts. The neighborhood is better off because of it." He paused, then added, "I'm thinking about getting an electric car myself. Would you mind telling me about yours?" I spent the next 20 minutes talking to George about electric vehicles, charging times, range, and cost savings. By the end of the conversation, he was sold on the idea and asked if I could recommend the electrician who installed my charger. "Sure," I said. "Carlos does great work. Just tell him I referred you." As George walked back to his house, I felt a sense of peace. The battle had been difficult and frustrating, but it had been worth it. I had stood up for my rights, changed my community for the better, and proved that HOAs couldn't just ignore the law because they felt like it. The following spring, the Meadowbrook Hills HOA held its annual meeting. The new board presented a transparent financial report, discussed upcoming projects, and actually listened to homeowner input. It was a stark contrast to the previous regime. During the open comment period, Helen recognized me. "Tom, you've been a big part of the positive changes in our community. Would you consider joining the board?" I thought about it. Part of me wanted to say no, I had had enough of HOA drama to last a lifetime. But another part recognized that the best way to ensure the community stayed on the right track was to be involved. "I'll think about it," I said, which earned some encouraging applause from the audience. Later that evening, sitting in my living room with my Tesla charging quietly in the garage, I reflected on the entire experience. I had learned several important lessons. First, knowing your rights is crucial. If I hadn't researched California law, I might have caved to the HOA's demands. Second, documentation is everything. Keeping records of all communications and actions had been essential to winning the case. Third, there are always more people on your side than you realize. You just have to find them. Most importantly, I learned that standing up to unjust authority isn't easy, but it's necessary. Patricia and the old HOA board had been able to bully homeowners for years because nobody challenged them. It took a lawsuit and a public court ruling to finally break their grip on the community. I did end up joining the board the following year. I figured that if I was going to live in a community with an HOA, I might as well help ensure it operated fairly and legally. Helen remained as president, and together with the other board members, we worked to make Meadowbrook Hills a place where people actually wanted to live rather than a place where they felt constantly watched and judged. We implemented several new policies based on my experience. First, anytime the board considered a fine or violation notice, we had to clearly document what specific rule was being violated and whether that rule was legally enforceable. Second, we established an appeals process so homeowners could challenge fines without having to resort to lawsuits. Third, we committed to following state law even when it conflicted with our CC and Articus, and we regularly reviewed our governing documents to remove outdated or illegal provisions. The changes were popular with homeowners, and property values in Meadowbrook Hills actually increased. It turned out that people preferred living in a community with reasonable rules and fair enforcement, rather than one run by petty tyrants. Patricia eventually moved out of the community about 18 months after the lawsuit. I heard she bought a house in a different neighborhood, one without an HOA. The irony wasn't lost on anyone. As for my Tesla, it remained plugged into the charger that had started this whole mess. Every time I pulled into my garage and connected the charging cable, I felt a small sense of satisfaction. That charger represented more than just a way to power my car. It represented the principle that individuals have rights that even HOAs must respect. I occasionally get emails from other homeowners across California who find themselves in similar disputes with their HOAs. They've heard about my case and want advice. I always tell them the same things. Know your rights, document everything, don't back down if you're in the right, and find a good attorney who specializes in HOA law. Many of them end up winning their cases, just like I did. Each victory makes it a little harder for overreaching HOAs to bully homeowners into compliance with illegal or unreasonable demands. Looking back on the entire experience now, I can see how it changed me. Before this happened, I was someone who generally avoided conflict and tried to go along to get along. The lawsuit forced me to find a backbone I didn't know I had. It taught me that sometimes the right thing to do is also the hard thing to do, and that standing up for principles matters even when it would be easier to give in. My time on the HOA board eventually came to an end after serving 2 terms. I had accomplished what I set out to do, helping to transform the organization from a source of fear and frustration into an actual community asset. Helen and the other board members continued the work, and Meadowbrook Hills became known as one of the better-run HOA communities in Sacramento. These days, when I drive through the neighborhood, I see several electric vehicles parked in driveways. Some have chargers mounted on garage walls, others use outdoor pedestals. Nobody questions them. Nobody sends violation notices. The HOA even offered incentives for homeowners to install energy-efficient upgrades, including EV chargers and solar panels. It's a far cry from the community I moved into years ago, where Patricia ruled with an iron fist and treated homeowners like subjects rather than members. The transformation didn't happen overnight, and it required many people working together, but it proved that change is possible. The $5,000 penalty that Judge Foster awarded me ended up going to a good cause. I donated it to a nonprofit legal aid organization that helps homeowners fight unjust HOA actions. If my battle could help someone else win theirs, then all the stress and frustration would be worth it. My Tesla is still going strong, now with over 80,000 miles on it. I've saved thousands of dollars on gas over the years, and the car has been remarkably reliable. Every time I charge it, which I do almost every night in my garage using that controversial charging station, I'm reminded of the principle that was at stake. This wasn't really about an electric car or a charging station. It was about the rule of law and whether HOAs have to follow it. Judge Foster's ruling made it clear that they do. HOAs serve an important function, but they operate within a legal framework, and when they violate that framework, there are consequences. The $23,000 in attorney's fees that the HOA had to pay came out of the community's reserve fund money that could have been used for improvements or maintenance. It was an expensive lesson for the organization, but hopefully one that prevented future legal problems. The new board made sure to consult with legal counsel before making controversial decisions, and they prioritized compliance with state law over personal preferences. I still live in Meadowbrook Hills. Despite everything that happened, I like my house and I've grown to genuinely enjoy the community now that it's under better management. My neighbors are friendly, the common areas are well maintained, and the HOA focuses on actual community needs rather than petty enforcement actions. Sometimes I run into people who are considering buying a house in an HOA community, and they ask my advice. I tell them to read the CC and Articles carefully before buying, to attend a board meeting if possible to see how it operates, and to remember that they have rights that HOAs must respect. I also tell them not to be afraid to stand up for those rights if necessary. The experience taught me something important about power and authority. HOAs derive their power from homeowners. We elect the board, we pay the dues, and we have the right to recall board members who abuse their positions. But that power only works if people are willing to use it. For too long, Patricia and her allies had operated without meaningful oversight because homeowners were too intimidated to challenge them. My lawsuit changed that dynamic. It showed that the board wasn't all-powerful, and that their decisions could be overturned by courts when they violated the law. That knowledge empowered other homeowners to speak up, which ultimately led to the recall election and the transformation of the community. I learned that legal protections are only as strong as people's willingness to enforce them. California's law protecting EV charger installation was on the books for years before my dispute, but it only mattered because I was willing to cite it, fight for it, and take the HOA to court over it. If I had just given in and removed the charger, the law would have been meaningless, at least in my community. Years after the lawsuit concluded, I got a call from a reporter at the Sacramento Bee who was writing an article about HOA disputes in California. She had heard about my case and wanted to interview me. The resulting article featured my story prominently and included quotes from Jennifer about the importance of homeowners knowing their legal rights. The article generated a lot of responses. Several other homeowners reached out to share their own HOA horror stories, and a few state legislators even mentioned using it as background for potential HOA reform legislation. I never expected my personal dispute to contribute to broader policy discussions, but I was glad if it could help prevent similar situations in the future. My relationship with electric vehicles evolved over the years too. After my positive experience with the Tesla, I became an advocate for EV adoption. I gave talks at local environmental groups about the benefits of electric transportation, and I always mentioned the importance of knowing your rights when it comes to charging infrastructure. Many people don't realize that laws exist to protect their ability to charge electric vehicles at home. Landlords and HOAs often try to prohibit or restrict charging, either out of ignorance or a desire to maintain control. But states like California have recognized that widespread EV adoption is crucial for environmental goals, and they've passed laws to prevent unreasonable barriers to home charging. My case became a small but meaningful part of that larger story. Judge Foster's ruling added to the body of case law showing that HOAs can't simply ignore state EV charging laws. Other attorneys started citing my case in their own HOA disputes, and several similar cases were resolved in favor of homeowners partly because of the precedent. I often think about what would have happened if I had backed down when Patricia first knocked on my door that day. The charger would have been removed, I would have wasted the money I spent on installation, and I would have been forced to charge my car at public stations inconvenient and expensive. More importantly, Patricia would have been emboldened to continue her authoritarian management style, and the community would have continued to suffer under her leadership. Instead, by standing firm and taking the case to court, I not only protected my own rights but sparked a transformation that benefited everyone in Meadowbrook Hills. The new board's policies attracted home buyers who appreciated reasonable governance, which helped property values. The community became a more pleasant place to live, which improved quality of life for residents. And future homeowners would be able to install EV chargers without facing the harassment I endured. There's a saying that hard cases make bad law, but I think fair cases can make good law. My case was straightforward, clear facts, clear law, and clear right and wrong. Judge Foster's ruling was similarly clear and left no ambiguity about HOA's obligations under California law. That clarity has helped other homeowners and hopefully deterred some HOAs from attempting similar overreach. If there's one thing I hope people take away from my experience, it's this. Don't let fear of conflict prevent you from standing up for your rights. Yes, fighting the HOA was stressful. Yes, It took time and money and emotional energy. But it was worth it, not just for me, but for my entire community. Sometimes the right thing to do is also the hard thing to do, and you won't know how strong you are until you're tested. I also learned the value of finding allies. Helen and the other homeowners who supported me made the experience much more bearable. Knowing that I wasn't alone, that other people recognized the injustice of the situation, gave me strength to continue when things got difficult. If you find yourself in a similar situation, reach out to your neighbors. You might be surprised how many of them share your frustrations. The legal system worked the way it was supposed to in my case. I had a legitimate grievance based on clear law. I presented my case professionally with good legal representation, and the judge ruled fairly based on the facts and law. Not every case turns out this way, of course, but it's reassuring to know that when HOAs overstep their authority, there are mechanisms to hold them accountable. My electric car charger still hangs on my garage wall, a constant reminder of the battle that was fought over it. It's just a piece of equipment, a white box with a cable and a connector. But it represents something much larger, the principle that homeowners have rights, that HOAs must follow the law, and that standing up for what's right can make a real difference. Every night when I plug in my car, I think about that principle. And every morning when I unplug it and drive to work, I'm reminded that sometimes the most ordinary things like charging an electric car can become the catalyst for extraordinary change.